Good morning. Be seated. All right, as announced, the Supreme Court of the State of Oklahoma is now in session. Our matter that's set for argument this morning is the matter of Alicia Stroble versus Oklahoma Tax Commission. It is case number 120806. And I understand that Michael Parks is going to present for the appellant, and I would ask for him to introduce the other folks at his council table.
My name is Michael Parks, and I represent Alicia Stroble. Ms. Stroble is seated here with me. And then, with the court's permission, I was going to let Mr. Okmulgee introduce the rest.
Thank you very much. All right. I understand that the counsel for the appellant, well, first of all, each side has a total of 30 minutes to present. I understand that counsel for the appellant is going to take the opening 3 minutes, and that the counsel for friend of the court, Muscogee Creek Nation, will take 15 minutes, and that counsel for OTC will have their 30 minutes allotted, and then the counsel for the friend of the court will have the final 12 minutes for rebuttal. Is that, if I've recited that incorrectly, then correct me. Otherwise, that'll be the order that we proceed. And with those, are there any other procedural announcements or questions that counsel may have of the court before we proceed? All right, you may proceed, sir.
Thank you. Thank you, Mr. Chief Justice, and may it please the court. I would like to begin by making a very brief statement, and then I will defer the balance of the argument time and responses to this court's questions to the Creek Nation. My client, Alicia Stroble, and I are in full agreement with the positions laid out by the nation in this matter. This should be a straightforward case. The parties agree that Ms. Stroble is a Creek citizen, that during the 3 tax years at issue, she earned her income working for the Creek Nation at its governmental complex within the nation's reservation, and that during this time she resided within the boundaries of the Creek Reservation, boundaries which the McGurk Court recognized to have continuing force. Those 3 facts are legally dispositive of Ms. Stroble's claim. For the reasons explained in our briefing, and as counsel for the nation will discuss next, under controlling principles of both state and federal law, Oklahoma has no power to tax the income of Creek citizens who, like Ms. Stroble, both reside and earn their income within their nation's reservation. As I noted, I will defer the remainder of the argument, including any responses to the court's questions to the Creek Nation. Because the OTC's arguments center largely on the legal status of the Creek Reservation, I believe it will be beneficial for the court to hear directly from the Creek Nation on those issues. Thank you.
Thank you, sir.
Thank you, Chief Justice Kane, and may it please the court. The Muscogee Creek and Seminole Nations appreciate the opportunity to present oral argument to the court in this critical matter. For more than 50 years, the Supreme Court has consistently reaffirmed the bedrock principle of federal Indian law that tribal citizens living and earning their income on their nation's reservations are categorically exempt from state income taxation. And Oklahoma has adopted that principle into its own positive law. But now the OTC asks this court to hold that Alicia Stroble, who lives and earns her income on the Mvskoke Creek Reservation and is a Muscogee Creek citizen, nevertheless must pay state income tax. In doing so, the Oklahoma Tax Commission asks this court to engage in an act of judicial resistance and to fundamentally rewrite both federal and state law. The nations urge this court to reject that invitation. The stipulated facts in this case, taken together, lead to but one conclusion under federal law. As the Supreme Court of the United States held in 1993 in the Sack and Fox case, which arose out of Oklahoma, states are, quote, without jurisdiction to subject a tribal member living on a reservation and whose income derived from reservation sources to a state income tax absent an express authorization from Congress. And all agree here that no such authorization has been provided by Congress. In the Chickasaw Nation case, which arose again out of Oklahoma just 2 years later, the Supreme Court reiterated this holding, making clear that the rule is a per se principle that is not subject to rebalancing by the courts. Quote, when a state attempts to levy a tax directly on an Indian tribe or its members inside Indian country rather than on non-Indians, we have employed, instead of a balancing inquiry, a more categorical approach. Absent congressional authorization, we have held, a state is without power to tax reservation Indians. Under this clear categorical rule, Alicia Stroble's taxable income is categorically exempt from state taxation. The same conclusion follows under the OTC's rules. Rule 71050-15-2 provides that tribal members living within the Indian country under the jurisdiction of their nation and earning their income within that Indian country are exempt from state income tax, and defines Indian country to include both formal and informal reservations. As the OTC stated in its opinion below,
Excuse me, counsel, could you tell me what the definition is of a reservation? I understand what an informal one is. What is a formal one?
yes, absolutely, Your Honor. In its opinion below, the OTC stated that language, formal and informal reservations, comes directly from the Sack and Fox case. And in the Sack and Fox case, the Supreme Court and the OTC, actually, in litigating the case, used the term formal reservation to reference any reservation established by the United States for the benefit of an Indian tribe that has not since been disestablished by Congress. So any existing reservation that has formal boundaries, which describes the Mvskoke Creek Reservation, as you know, as the court held in McGirt. The Creek Reservation was established by the United States and the Creek Nation and has never since been disestablished by Congress, and its formal reservation boundaries continue to enjoy jurisdictional force. So under the definition employed by the OTC itself, and it's a rule that's stated in mandatory terms, a Creek citizen like Alicia Stroble is again exempt from the state income tax.
Counselor, isn't it true though, even in those cases, there is a federal statute in which the tribes have to petition the Secretary of Interior to put land in trust in order for there to be a federal mandated exemption from for tax purposes against the state. Isn't that correct?
No, Your Honor, that I would respectfully but strongly disagree with that statement. There are several ways in which Indian lands become exempt from state taxation. You pointed to one, which is where lands are taken into trust for a tribe, and to go back to Justice Cogger's question, those are what the court has referred to as informal reservations. That's what the Sack and Fox case said. Those are exempt from taxation. But so too are reservations that have been formally established by treaty for an Indian nation. And there the court has been very clear. The Sack and Fox case, the Chickasaw case, I could list 4 or 5 others, start going back to McClanahan in 1970, where the court has said that all lands within a reservation are subject to this categorical rule. And one thing, and this goes directly to one of the OTC's arguments, one thing that the court has been crystal clear about is that this rule applies equally to fee land or to trust lands within a reservation.
If you lose your argument that the OTC doesn't have the right under the state constitution for the state to tax all of its citizens, go with me there with that assumption, and I know you're not admitting that assumption. Both federalism issues and the state's right to tax, and I think what you would get down to is, what would you agree, the Bracken test, meaning if there isn't a federal preemption or a federal mandate that we have to apply, what in this instance on income tax, collecting it on a citizen that lives within the city and county of Okmulgee, getting fire, education, trash, all those things, how would that infringe on tribal self-government under the Bracken test?
And so I will go with all of your assumptions, of course.
Right. I'm not asking you to agree with those, but if that is the end result, how do you then get past tribal self-governance and infringement?
Well, I think there it's very instructive to go back to what the Supreme Court has said in 5 or 6 opinions, where it has said we're not going to do a rebalancing every time because the tribal and federal interests are so clear in having this immunity from taxation for 2 different reasons. One is Justice Scalia said in the Blackfeet case, in the Yakima case, he said the power, it's well understood, the power to tax is the power to destroy. And historically, there's been a great concern about state taxation of reservation Indians and reservation tribes, and a very strong federal interest in guarding against that encroachment. At the same time, there is an extremely strong tribal interest in being able to earn tax revenue from the tribe's own citizens to support the tribe's own governmental activities. And this goes directly to your question, is a point I really want to underscore. The Muscogee Creek Nation, for all the talk about revenue concerns in this case, at the time of McGirt was expending $350 million a year within the reservation on governmental services for the benefit both of Creek Nation citizens and non-citizens alike, including non-Indians, for everything.
Why do you think?
Want to underscore the Mvskoke Creek Nation, for all the talk about revenue concerns in this case, at the time of McGirt was expending $350 million a year within the reservation on governmental services for the benefit both of Creek Nation citizens and non-citizens alike, including non-Indians, for everything.
Why do you think McGirt applies?
I'm sorry, Your Honor?
Why do you think McGirt applies to this case? It's a criminal case.
Well, it's an excellent question. It's one of the OTC's arguments. The OTC says, look, McGirt only had to do with the Major Crimes Act, so it only found a reservation exists for purposes of the Major Crimes Act. But I do not think that reading of the case can be sustained in any way. McGirt found 2 things. First, that Congress in the United States had established a reservation for the Creek Nation. That had nothing to do with the Major Crimes Act. It rested on treaties and statutes that predated the Major Crimes Act by decades. The court then found that Congress had not disestablished the reservation, again looking to statutes and governmental acts that postdated the Major Crimes Act and had nothing to do with the act itself. The court's holding was that a reservation existed and that therefore had various jurisdictional consequences. From the finding of a reservation Indian country status, various consequences follow that extend beyond the simple facts of the case. And that's not simply me saying this, but this court has said exactly that. Milne v. Hudson was a case about civil protective orders. And far from saying that McGirt had no applicability to that non-Major Crimes Act case, this court said, quote, McGirt sets the stage for our analysis, and then went on to say, and I will quote the exact language here, that with McGirt held that the Muscogee Creek Nation Reservation was never disestablished and continues to be Indian country. With that finding, activities supporting the protection order in this case occurred in Indian country. Our analysis thus focuses on the issue of civil jurisdiction in Indian country. The OTC never acknowledges the significance of the Milne holding for this case. This court has already clearly held that McGirt's determination of reservation status applies beyond the confines of the Major Crimes Act, and in fact applies squarely in the context of civil jurisdiction, which is where we are today. I've discussed already two of the arguments that the OTC makes in resisting the conclusion that would otherwise naturally follow from federal and state law. The one that you just, going to the question you just raised, Justice Cogger. The second going to the issue of fee lands within the reservation and whether they count as reservation land. And there it just bears reiteration that for 60 years the Supreme Court has held that to be established law, going back to the Seymour case, and has done so based on the very clear language of the federal statute, 18 U.S.C. 1151, which provides in terms that could not be clearer that reservation lands include all lands within the reservation boundaries, notwithstanding the issuance of any patent. And McGirt reaffirmed a long line of Supreme Court cases saying that that language means exactly what it says.
So who owns her property? Does she own it, or does the tribe own it, or actually the federal government owns it?
No, it's owned in fee.
By her?
Yes,
Okay.
Your Honor. Yes. And again, that the jurisdictional implication of that is because it is found within extant reservation boundaries.
Hasn't the Tax Commission said that at least 90% of the people living in the Mvskoke Creek Reservation are non-native?
Yes, Your Honor. Not only the Tax Commission said that, but the McGirt court itself said that. In McGirt, Oklahoma argued 90% of the people within the reservation boundaries are non-Indian, 95% of the land is fee land. That should somehow suggest that the reservation has been disestablished, and the Supreme Court stated very clearly that that is not how the law works, that reservations are only disestablished where there is a clear statutory indication by Congress of the intent to do so. Congress has never done so. The fact that there are fee lands and non-Indians living within the reservation, those demographic trends do not suffice to disestablish a reservation. And the court, again, has held consistently on one of the leading taxation cases, is the Moe case, in which Justice Rehnquist rejected arguments very similar to what the OTC makes here, that because the communities were integrated, there were a large presence of non-Indians, that this categorical tax rule did not apply. And Justice Rehnquist there pointed to...
Right, but what about the Sherrill case? I mean, we can't ignore that. I mean, obviously custom and usage was considered by the Supreme Court, led by Justice Ginsburg, saying, because this custom and usage in New York has been gone on for so long, we're not going to upturn the apple cart here and let you reestablish your reservation status in order to avoid taxation. So they do consider custom and usage and have what's the difference between what you're discussing and why the Supreme Court would decide to go that way in Cheryl, like maybe the things that Justice Gert was pointing out?
Yes, thank you for asking about Cheryl, because obviously it is a central component of the OTC's argument. Cheryl is not and has not been treated as a magic wand that the commission can, or a state can wave around whenever they don't like the result of a case. The Cheryl applies in very specific circumstances that are categorically different from the circumstances present here. In two major ways, that case was the polar opposite of ours. First, the Cheryl Court, Justice Ginsburg, was very focused on the fact that the Oneida tribe had sold the lands in question and had abandoned the area for 2 centuries. And 2 centuries later was trying to come back into a territory and rekindle the embers of sovereignty. That, of course, is categorically the opposite of what the Supreme Court itself stated about the Creek Nation, which has been...
But they abandoned it because it was sold illegally back in the 1800s, correct? Without the federal government approving of the sale. And that's the reason why they were getting reparations in the first place for the sale of all the thousands of acres. So if you go back past the abandonment of the repurchasing, the underlying complex issues are just like here in Oklahoma, where people were stealing the Indians' land. That happened to the Oneidas as well, correct? I'm sorry, Chief. I'm asking a bunch of questions. Can he keep going?
Yes, let's let him finish this, and then I'm going to...
All right, I apologize. Go ahead, sir.
Oh, no, and I appreciate the questions. The main distinguishing feature, and you're right, that absolutely there's a lot of illegal activity in Oneida, or activity that hadn't been blessed by the federal government. But the upshot of that had been that the Oneidas who had voluntarily sold the land, had gone west. It essentially had been removed west and entirely out of the territory in question. Here, of course, the Creek Nation reservation is on the other end of the removal process. The Creeks were removed to this reservation. It was solemnly guaranteed to them. They were promised the right of self-government forever over these lands, and the Creeks remained ever since. And as McGirt emphasized, exercised governance over this land, have continuously exercised governance for the past 200 years. And the immunity, this is the second critical distinguishing feature, the immunity claimed here is by virtue of the principles that follow from that, by the bilateral agreement of the United States and the nation that this would be a reservation. Because the other thing that really concerned the court in Cheryl was that the Oneidas were unilaterally trying to create an exemption for themselves. They were coming back into this territory, buying land on the open market and saying, presto, that provides for an immunity. And it wasn't any immunity, it was a super immunity. Here we're talking about an immunity from tax income, which is well recognized, as I've said, in a long line of Supreme Court cases. There, the Oneidas were claiming an immunity from property taxation, which does not follow naturally from reservation status in this day and age. The understanding, the modern day understanding, is that Congress has generally blessed property taxation on reservations, including the Creek Reservation. But the Oneidas were arguing for something over and above that, a super immunity that they could unilaterally create themselves. And the Supreme Court said, we're not going there. We're not even going to address your claim that a reservation still exists, because the combination of abandonment and unilateral reviving of sovereignty was too far for the court. It was a bridge too far.
All right, thank you, sir. I think you've answered. Thank you.
Thank you very much.
Vice Chief, do you have any final question there?
I do. Thank you, Chief. Counsel, I have 2 questions. I understand your argument presents an interpretation of the Oklahoma Administrative Code, but I want to question about the federal case law. McGirt defined Indian country under the criminal statute 1511, and today, are you not asking us to borrow from 1151 to grant relief to your client?
Yes,
we have
yes.
to borrow from 1151 to get to where you want us to go.
Under federal law, 1151 governs as you state, because it provides the definition.
And the U.S. Supreme Court has yet to do that. You're asking us to do something that they have yet to do. Because in McGirt, they said, I believe the Tax Commission quoted this. The only question before us concerns the definition of Indian country as it applies in federal criminal law under the Major Crimes Act. They limited it, as Justice Cogger referenced, to the Major Crimes Act. You're asking us to borrow from that today and apply it to a civil context here in Oklahoma.
So, two answers to your question, Your Honor. First, the court went on, your court went on in the very next sentence after what you quoted and said, of course, many federal civil laws and regulations do currently borrow from Section 1151 when defining the scope of Indian country. So the court recognized that there are...
But the court didn't do that. They recognized it, but they didn't take that next step, did they?
Well, no, I mean, the court just addressed the court.
And you're asking us to do just that today. You're asking us to borrow from 1151 to grant relief to Ms. Stroble.
I think I understand the thrust of the question. I would frame it slightly differently, which is this. McGirt held there to exist a reservation. And in federal Indian law, we don't have categories of reservations for certain purposes and not for others. It said Congress has never disestablished this reservation for any purpose. Once you have a reservation holding, various principles flow from that. And what we are asking you to do is simply to recognize and vindicate the long-established principle that where you do have a reservation, there's an immunity from state income taxation.
Let's get this into language that I understand. I'm from Tishomingo, Johnston County. It is 100% Chickasaw country with the exception of the eastern sliver, which is Choctaw country. If we rule for Ms. Stroble today, would that decision not by implication apply to all of eastern Oklahoma, including my home county, Johnston County?
I think there's a very good chance that the holding would apply. Well, the holding would apply to other recognized formal reservations.
And that would mean that every Chickasaw Indian living and working in Johnston County for the Chickasaw Nation would be exempt from state income taxation.
Yes, if they're within the...
What about a Choctaw citizen living in Johnston County working for the Chickasaw Nation? Under your analysis, would that person be exempt?
No, Your Honor, because the court, and it's a great question, the Supreme Court has been very clear.
The U.S. Supreme Court.
The U.S. Supreme Court, that the categorical rule only applies to tribal citizens.
Thank you, counsel. I have no further questions, Chief.
Justice Cogger, do you have any additional questions?
Now, I'm troubled by jurisdiction. That's one of the rules. You have to be under the jurisdiction of the tribe. And this extension could seem to me to go a very long ways. What if I'm living in Okmulgee on fee simple land within Indian country, and the city of Okmulgee has an ordinance about you can't have more than 4 dogs and you have to have a fence around your swimming pool? Well, now, who has jurisdiction over that?
With respect to issues including zoning, licensing, other claims that have been raised, the rules are different than in the income tax context. So, as I said, when you have a reservation holding, there are different buckets. And the zoning bucket is a bucket that allows for more in the way of concurrent jurisdiction in certain circumstances. So in that situation, it might, and it depends on whether somebody's a tribal citizen or not, but there could well be, for example, shared zone jurisdiction.
But it says under the jurisdiction of the tribe. So is this zoning under the jurisdiction of the tribe?
Well, with respect to tribal citizens, yes, absolutely. The tribes have zoning authority with respect to their own citizens, very limited authority with respect to non-Indians.
So there would be like a quilt patch, a different application for if I do not have tribal citizenship and I'm living next door to you, we're going to have 2 different rules?
Well, not necessarily, Your Honor, for several reasons. One, there's a great deal of governmental cooperation on those issues. So the Muscogee Creek Nation, for example, has an assimilative code where it borrows and assimilates a great deal of rules from neighboring jurisdictions, including, for example, say the city of Tulsa. So there is a great drive amongst the governments to have uniformity. The traffic code, same sort of thing. So everyone's interested in good governance, so you're not necessarily going to have a patchwork. And then the more fundamental point, and I can't stress this enough, we have these different buckets, as I like to call them. When you have a reservation holding, you have different buckets. We're in the income tax bucket, where the laws are very clear. It's this black letter immunity that has been reaffirmed for decades. It's very hard for the OTC to argue against that black letter law. It's also very hard to argue, and I'd like to get to this point at some point, that it's going to have any kind of devastating consequences for the state fisc. So what they want to do is say, well, let's look at this zoning bucket or this criminal bucket, different buckets, where the laws are different and where this court is not today deciding how the principles apply with respect to those other buckets. The case before this court today is the income tax case, just like the case before the Supreme Court in McGirt was a Major Crimes Act case. But because there are different buckets and different consequences might follow, what they want to say is, well, you should just scrap or ignore the overall reservation holding to begin with. Ignore what the United States Supreme Court said, that this is a reservation, because someday you might have to look at these other buckets and, the rules there might be more complicated. Well, that's not how application of the law or judicial decision.
But as Justice Rowe pointed out, you're asking us to make more buckets.
We're simply looking at one bucket, which is the income taxation bucket, because you have a law-abiding citizen here, Alicia Stroble, who for decades paid state income tax all her adult life, even though under the law she was not required to, who has now said, look, I understand that as a Muscogee Creek citizen, if any government is entitled to my revenues, it should be the Mvskoke Creek Nation Reservation. That's clear law. And all we're asking is for that straightforward principle of law to be vindicated.
This sounds like a bucket list. I wanted to just ask, isn't it true that the U.S. Supreme Court incorporated 1151 definitions in the Sack and Fox case all those years ago on the issue of taxation?
Yes, Your Honor.
I mean, this whole concept, and I'm looking at the administrative rule for our Oklahoma Tax Commission, which says C, 18 U.S.C. 1151. I look at the report of the Tax Commission that makes it very clear that everyone accepts for the purpose of income taxes, we are here on one issue. Is that correct?
That's absolutely correct.
And that is a question of whether or not this court follows the United States Supreme Court law that's been in existence for almost 30 years.
That's exactly right. And one of the critical things here is that the Sack and Fox case, everyone, including the Oklahoma Tax Commission, agreed that when it comes to a formal reservation, one with boundaries that has not been disestablished, this clear rule of tax immunity applies. Nobody was arguing about that. The question was whether, if you had other lands, trust lands, etc., whether the rule would extend to those. But this core principle, as you rightly state, has been so well accepted for so long that what the OTC is now asking for the court to do is only one of two choices to rule in favor of the OTC. Either one has to ignore McGirt and its holding that the Creek Nation is an extant reservation, or two, one has to somehow go and rewrite what you very rightly say is decades worth of accepted law, both at the federal and the state level.
And the establishment, the issue of the disestablishment in McGirt is not based on 1151. Is that right?
Exactly. The disestablishment question was, did Congress ever enact any statute evidencing an intent to disestablish? And the court looked at a large variety of statutes that again had nothing to do with the Major Crimes Act to find no, Congress has never expressed that intent. One other clear indication, by the way, that that McGirt applies well beyond the confines of the Major Crimes Act is actually a case that the OTC is fond of citing, which is the Castro-Huerta case from the Supreme Court, which came along several years later. Castro-Huerta was not a Major Crimes Act case. It arose under the General Crimes Act. And the court, in that case, took as its jurisdictional predicate that the Muscogee Creek Nation Reservation is an extant reservation. And then it had to decide, and we were off in a different bucket there, what rules apply there. But there was no question in the court's mind that this was Indian country.
Justice Winchester, do you have any questions?
I did. I'm concerned about local taxes, cities and counties. If we determine that Ms. Stroble is a part of the reservation and that reservation encompasses all of these counties, what are the implications for her local taxes that she or other citizens of the nation would have to pay. Retail sales taxes at grocery stores that were within that, and also property taxes that support local schools. What's the impact on those taxes?
Yes, thank you, Your Honor. Two-part answer. First, with respect to the taxes themselves, it varies depending on the nature of the tax. So property taxation, clearly established law, she would still continue paying her property taxes. That's viewed as a tax on the property. Congress has authorized the taxation of fee lands within reservations. Some of the other taxes you mentioned, which are viewed as more as taxes on the person, which might include a sales tax, for example, or the income tax, could not be levied on her, which takes me to the second part of the question, which is the consequences for state and local fiscs. I think this is a really critical point to underscore. The OTC has talked about dire cuts in services, et cetera, if you were to affirm our position. I think nothing could be further from the truth. The Oklahoma Tax Commission, in its own findings, its report about the fiscal impact, stated that the annual impact, if the court were to side with the Creek Nation position, would be $21 million a year on the Creek Reservation. And if you took all 5 Eastern Oklahoma reservations, about $72 million a year. The OTC said that's a very high side estimate because that assumes that all Indians living and working within the Creek Reservation, for example, are Creek citizens, which we know not to be the case. But even take those numbers, 21 million or 70 million, those numbers are dwarfed, one, by the expenditures of the Creek Nation government itself on services, and it's critical to underscore these services are for the benefit not just of Creek citizens, but non-Indians as well, and include everything from the provision of infrastructure, police, the Lighthouse Police Force, family violence prevention, water, utilities. The Creek Nation works very closely with local governments throughout the reservation in providing these services. And the Creek Nation's current budget is $450 million a year being expended on those services. So far dwarfs the $21 million. The second thing is that after the OTC issued that report with those findings in 2021, the state legislature, with full knowledge of those findings, legislated a state income tax cut that was to the tune of $350 million a year, understanding that there might be a budget hit from McGirt, but thinking that the state fisc was plenty robust to absorb that and far more. Since that state income tax cut, state revenues have continued to grow, and just yesterday, the governor issued an executive order convening the legislature in special session to consider another 0.25% cut in the state income tax, which the Board of Equalization has estimated would amount to another $250 million in revenue diminishment for the state. So that number again dwarfs the fiscal impact of this case, and I think belies the OTC's claims that for equitable reasons under Sherrill, this court should depart from a straightforward application of the law.
Thank you.
Justice Combs?
Thank you, Chief. I'm going to try to bring it back down to the issue that I see at hand. This is a tax case, an income tax case. And follow up on the Vice Chief Justice's question with regard to borrowing the definition under the Title 18, 1151. Didn't the Tax Commission borrow that definition as well in the Administrative Code when they refer to Indian country and they say C 18 U.S.C. 1151, which is the very statute which defines Indian country? Didn't they borrow it as well?
Yes, they absolutely did, Your Honor, and it's very interesting. The McGirt says in the language I quoted after Vice Chief Rose quote, McGirt says this collateral drafting choice made to borrow 1151 for other statutes doesn't have any effect on our interpretation of 1151. We're going to follow the law. The OTC, to your point, first cites the 1151 in the rule in question. And in an OTC decision from 2021, this is decision 2012-12-080-04, a precedential opinion, states, quote, the OTC falls within that set of entities that, quote, made the collateral drafting choice to incorporate the Section 1151 definition of Indian country into its regulations. So exactly what you said the OTC is.
So not only did the Tax Commission use the definition in the Sack and Fox case, a civil taxation case, but they also followed up with a reference to the Major Crimes Act definition of Indian country.
That's exactly.
And you're not borrowing it, they put it out there.
They did. They
Thank
did in the
That's all.
positive letter of the state regulations.
Justice Darby? Any final questions from Justice Keene?
Yeah, just a couple. You said that she's been paying income taxes for how long?
Her entire adult life.
Okay. And as far as I know, this is the first time she's challenging the fact that she shouldn't have been paying them her entire life because the reservation was never disestablished like in McGirt?
That's correct, Your Honor.
Okay.
McGirt made clear that the reservation still exists, and
Right,
she's-
but they were fighting that criminally for a very long time, right? I'm talking about your income tax bucket, where there hasn't been a challenge for a very long time until now, because I understand, it's been established, now you get to claim it is. But I'm asking you, was there ever any challenges by her prior to this to say, I shouldn't be doing this because I live on a reservation?
I can't speak for all Creek citizens. I believe there have been challenges over
Okay.
time. I understand Ms. Stroble to have made her challenge in the way
Through
from
the
McGirt.
tax commission possibly? Or to a court?
Both, Your Honor.
Okay, and then, I'm just curious on your thoughts. Could the tax commission amend their rule and just say, we're not gonna adopt that definition anymore and we don't have a problem?
Well, I trust and hope that the tax commission, views itself as bound by the dictates of the supremacy clause in federal law, and that any amendment it makes to its regulations would continue to conform
But they could
to
do
federal
it.
law.
But I understand that, but you didn't answer my question. But they can do it. That might not, you might argue it's not right. But
They can,
do
they
it.
can of course amend the
Okay.
regulations.
All right, I waive.
May I just go back to Justice Keene's first question for
Well,
30
I'll
seconds?
defer to Justice Keene if she needs a further
Are you
answer.
gonna talk to me about retroactivity and latches?
Yes, well, I want to underscore the point. It is not easy for a tribal citizen to do what Ms. Stroble has done. Even in the wake of McGirt, with the McGirt holding, Creek Nation professionals like doctors and nurses who have withheld their income tax in a law-abiding way, cited the state regulations, they are being threatened with the revocation of their professional licenses. So it takes a lot of courage for an individual like Ms. Stroble.
Is that in the record, Counselor? Or are you just saying that this morning?
I'm representing that to the court. It's not in the record.
Okay.
We're an advocate.
I waive, I don't need.
Okay.
Okay, thank you, sir.
Thank you, Your Honor.
All right, the appellee will have 30 minutes.
Thank you, Mr. Chief Justice, and may it please the court. This case presents one of the most consequential questions to arise in the wake of the United States Supreme Court's decision in McGirt. The question before this court is whether a tribal member is entitled to invoke the income tax exemption because the tribal member lives on fee land within the historical territory of the Muscogee Creek Nation. The Tax Commission reasonably determined that such fee land does not constitute Indian country for purposes of the definition contained in the Oklahoma Administrative Code, which is conceitedly worded differently from the definition of Indian country in the United States Code that was at issue in McGirt. Under the framework recently established by the United States Supreme Court in Castro Huerta, no source of federal law preempts the state's jurisdiction, and the state's interest in imposing its non-discriminatory income tax on its citizens living on unrestricted fee land outweighs the minimal tribal interest here in avoiding such a tax. And under the United States Supreme Court's decision in Sherrill, even if federal law did preempt the state's jurisdiction, the long passage of time since the Creek Nation exercised sovereign authority over the land in question bars the invocation of the Creek Nation's renewed sovereignty as a defense against taxation. The Commission's order denying appellant's requested exemption should therefore be affirmed. Now, I promise the court I'm not going to spend my entire 30 minutes just talking at the court. I welcome the court's questions at any point during my presentation. But maybe it makes sense for me to start with just a little bit of a roadmap here, because my good friend, Mr. Kanji, spent his argument kind of weaving together all of these arguments. In fact, there are three discrete arguments before the court today. The first, the question of state law, the interpretation of Administrative Code 71050-15-2A, and whether the Tax Commission's interpretation was a reasonable one here. Second, the question of preemption. Does federal law preempt the state's exercise of jurisdiction here? And third, and separately, the question of whether the equitable principle embodied in the Sherrill decision would nevertheless displace the assertion of renewed tribal sovereignty. Now, we, the Tax Commission, have to prevail on the first issue, and we have to prevail on either the second or the third issue in order to sustain our position here today. And so with the court's leave, let me start with the question of state law here. Our fundamental submission is that the Tax Commission reasonably determined that appellant does not live within Indian country for purposes of the definition in section 71050-15-2A. Now, appellant must show that she lives on either a formal or informal reservation under the regulation. I think it's quite clear that she doesn't live on an informal reservation because that term is defined in the regulation. It extends only to lands held in trust or retained by the tribe. And as Mr. Kanji conceded, appellant here, Ms. Stroble, obviously lives on fee land. So then the question becomes, does she live on a formal reservation? And our fundamental submission is that the Commission reasonably construed the phrase formal reservation. And Justice Coger, you asked my friend how he would define formal reservation. Let me tell you how we define it. We define it to extend to lands that are reserved for the tribes and to which the federal government held title in trust. And so formal reservation by its terms does not extend to unrestricted fee lands contained within the historical territory of a tribe that never had a reservation in that sense. Now, we think that that is the better interpretation under the plain text of the regulation.
But do you have any authority for that? Is that just your perception, your interpretation of what a formal reservation is?
So a formal reservation is not a concept under the federal definition in section 1151. As my friend Mr. Kanji indicated, that definition refers simply to all land within the limits of any Indian reservation. So again, the term formal reservation is contained in the state's definition. It's not contained in the federal definition. There is
I don't find it that clear.
Well, if you don't find it that clear, then my submission would be that the Tax Commission is entitled to deference here in interpreting that phrase. And is that phrase susceptible to our definition? Certainly it is. The definition that we're offering is the definition that the BIA uses for reservations in its own frequently asked questions. And I think it accords with the traditional understanding of what it means to be a formal reservation. My friend Mr. Kanji eventually offered, in response to your question, a definition. And his definition was, quote, a formal reservation is, as he put it, simply a reservation with boundaries. But I think that would erode the distinction between formal and informal reservations entirely. And again, when you look at how federal law defines, not just formal reservations, but reservations, again, it is the traditional sense of a reservation that where you're talking about lands that were reserved for the tribes that the federal government owned and held in trust. And so, again, if there is any doubt about this, Justice Coger, we would rely on the fact that the Commission is entitled to deference here really for two reasons. First, as an agency exercising its expert judgment, but second, under the traditional canon of interpretation, that exemptions to state tax provisions are strictly construed. This exemption is entirely a creature of regulation. It's not contained, as you will be aware, in any of the state's tax statutes. And so if there is ambiguity here, that ambiguity for purposes of the state law question should work to our favor. Now, I want to really address directly the argument that I think Mr. Kanji is making on the state law question here. And if I'm characterizing it incorrectly, he can correct me when he gets up on rebuttal. But I think that the argument here is really a sort of triple bank shot argument. The first premise of the argument is that this phrase, formal and informal reservations is taken from the Supreme Court's decision in Sack and Fox. And in that portion of Sack and Fox, the United States Supreme Court was discussing the federal definition of Indian country. And for that reason, the tribe and appellant argues the regulatory definition of Indian country should be viewed as coterminous with the federal definition. Now, there's one obvious fundamental problem with that. If you look at the language of the state's definition, again, in Administrative Code 710.15.2a1, and you put that language alongside the federal definition in Section 1151, the language could not be more different. And there are two differences that I think are particularly significant. The first is this concept of a formal or informal reservation. And notably, again, the definition of informal reservation is limited to particular types of land, lands held in trust for a tribe, or lands that were retained by the tribe for use as tribal lands.
Why do you think the Tax Commission limited it or made that definition different than the federal government?
Well, you know, we don't really have any sense for why the Tax Commission adopted this particular language at the time. It was adopted, Justice Keene, in the wake of the Supreme Court's decision in Sack and Fox.
Because they knew where the land was, possibly? They could delineate where they were going to allow the exemption or not?
Well, I think I would say this, Justice Keene. You know, there wasn't really any contention about the definition of Indian country at that time in the state of Oklahoma, for the obvious reason that at that time in the state of Oklahoma, there were no formal reservations. There are no formal reservations in the state of Oklahoma. And in the wake of the Sack and Fox case, it was quite clear that at minimum, as a matter of federal preemption, that the state would be unable to tax, for instance, lands held in trust like the lands at issue in Sack and Fox. But I mentioned that there were two differences. Let me tell you what the second difference was, which was that in the definition of Indian country in Section 1151, as the court will be aware, that definition refers to, quote, all land within the limits of any Indian reservation. And again, the definition in the administrative code doesn't say all land within an Indian reservation. It actually delineates particular types of land, at least with regard to informal reservations.
But counsel, on that point, you're asking us to construe the Oklahoma Administrative Code in the same manner that the Tax Commission construed it. And you're asking that we not borrow from 1151 the definition of Indian country that the U.S. Supreme Court applied in the Major Crimes Act holding in McGirt. You're asking us to do both of those things, correct?
I think that they're one and the same thing, Vice Chief Justice Rowe. We are certainly taking the position that the definition in the administrative code is narrower than the definition in the federal statute that the United States Supreme Court construed in McGirt.
I don't disagree with that, but how do you get past the OAC reference to 1151, as has been noted by my colleagues and your opposing counsel, that this is written into state law?
Sure, so I'm happy to address that C citation because I know that that was the subject of some of the questions during the other side's argument. The C citation does not mean that the Tax Commission is saying that that definition is identical to the federal definition. It is
then why does it not say but C?
Well, like all C citations.
This goes back to the first year of law school, counsel.
So
there's C and but C. Or C also. This says C. S-E-E for the record.
And when a lawyer cites something with a C, it doesn't necessarily mean that the authority is all fours. It simply means that the authority is supportive. And what is the best evidence of that? It turns out that if you actually look through the administrative code, it is replete with C citations of this variety, including in contexts where it is obvious that the state definition and the federal definition differ. I'll give you just one example. If you look at 71065-1975, that is a provision that defines what sort of donations are non-taxable under state law. And at the end of it, there is a citation, much like this one, in brackets and all, that says, see IRS Revenue Rule 67246. Now, it turns out that if you look at this, that revenue ruling isn't even about the same kind of tax. It's about charities as opposed to individuals. But it's quite clear that the state's definition by its terms in that regulation is stricter. And I can assure the court that there are many more, and we'd be happy to provide a supplemental list of those citations if the court wants them. But the fundamental point that I want to make here is that if the Tax Commission wanted the definition to be coterminous, it would not have been hard to use exactly the same language in Section 1151, or, as is done elsewhere in state law, to simply say there's a tax exemption for Indians working or for tribal members working or living on Indian country as defined by Section 1151. And if you take a look at page 9 of our brief, we cite statutes, Oklahoma statutes, where that Indian country definition is incorporated in precisely that way. I would concede freely, Vice Chief Justice Rowe, that if this definition said Indian country is as defined in Section 1151, that this would be a different case. Our submission is simply that the C citation is not the same thing here, particularly where you have different language, and particularly where the Tax Commission is entitled to some degree of deference if there is any ambiguity. And the other thing I would just say is to remind the court of a common sense point here, which is that there can be little doubt that the interpretation that we are advocating today is the one that the commission that promulgated this rule would have intended. And we take the point that is made in Appellant's reply brief, that there will of course always be circumstances where statutes or regulations are applied in novel circumstances after they are initially promulgated. But the dramatic departure in the scope of the exemption is something that we would respectfully submit that this court should take into account here.
So how many are already, apart from this question, how many tribal members are already getting this exemption?
So the latest information that I have from the commission is that as of January the 9th, there have been 11,855 such claims. And I think Mr. Kanji's numbers in terms of the consequences of this are roughly accurate. We've updated them slightly, so just for the court's benefit, I think the latest numbers, which were a 2022 estimate, were that for the Creek Nation for 1 year, we're talking about $22.7 million. For the 5 tribes in total, $75.3 million. The 3-year totals are $68.1 million and $225.9 million, respectively. Now, my friend Mr. Kanji kind of disparages that and says, well, you know, when you look at that in comparison with the entire state budget or the amount that the Creeks spend and the governor is proposing tax cuts, you know, maybe that's not a lot. I mean, maybe this just speaks to where I come from, but $225 million sounds to me like a heck of a lot of money. And the critical point is that that is money that the state needs because the state is providing services across eastern Oklahoma. This is not like a traditional reservation, like, say, the Navajo reservation that was at issue in the McClanahan case. If you look at that portion of Arizona, the state is obviously not providing schools. It's not providing police and fire. By contrast, as this court knows full well, throughout eastern Oklahoma, the state is bearing the disproportionate burden of providing those services. And the other thing that Mr.
Wait a
Kanji...
minute. The tribes are providing a lot of services, roads and bridges, housing.
The tribes are providing some services, to be sure.
In cooperation with the state of Oklahoma.
In cooperation with the state of Oklahoma. But there's no doubt that the state is providing the predominant services. If you look at those portions of Tulsa that are now Indian country for federal purposes under McGirt. Of course.
90% of those people are Oklahoma taxpayers, not making claims here.
That is correct. But again, I think that the amount of money...
And 95% is fee, owned in fee. And we've already heard that property taxes are not implicated here.
Property taxes may not be implicated, but tribal members who live on fee land are going to be able to claim this exemption. To get back to Vice Chief Justice Rowe's question to my friend, I think that, you know, the Cherokee tribe member who lives on fee land in Indian country will satisfy that requirement if the court rules in favor of the tribe here.
On income tax.
On income tax,
right.
That is correct. And the other thing I would just add is that I think that my friends on the other side sort of criticize this because they say that our estimates assume that all tribal members who are eligible are going to claim the exemption. Whether or not they're doing that entirely, I think we can all take judicial notice of the fact that the minute this court issues a decision definitively resolving the scope of this exemption, it would be malpractice for any tax accountant or advisor not to tell a tribal member to claim this exemption. And obviously, a ruling in the tribe's and appellant's favor here will have consequences for the sales tax, as Mr. Kanji acknowledged, and for other types of taxes as well, even if it won't for instance, for property tax. I want to say just one...
Counsel, if I can, you've indicated that a Choctaw or a Cherokee member will be making this same claim for exemption. But under the exemption code 7105015-2B, instances in which the income is exempt, 1, the member is living within Indian country under the jurisdiction of the tribe to which the member belongs. By its own definition, this would be limited to those areas where you have a tribal member living within their own tribal boundaries, working for their own tribal government. That's the 3 criteria. That's all we're talking about in this case. We're not talking about whether or not it extends to anyone who happens to be a member of an Indian tribe, are we?
So,
by your own terms.
I take the point, Justice Combs, that where you're dealing with a tribal member who's living or working on the land of another tribe, that may not be within the scope of the exemption by its terms. However, I want to correct just one thing you said, which I think is important. It's not just people working for the tribal government. It's anyone who's working on the land of their tribe, and of course that's now broadly defined in the wake of the Supreme Court's decision in McGirt. So, so it's broader than just people like Ms. Stroble who happen to work for the tribe itself. I want to say just one other thing about the state law question before we turn to the federal law issues, and that is that Appellant and the tribe set great store by the fact that the executive director of the OTC issued a report in which, in their view, the Tax Commission took a contrary position. That is simply not an accurate characterization of that report, and I would invite the court to take a look at the report, which is at pages 191 to 194 of the record.
Counselor, is that the report that the commissioners said they did not approve in advance?
Yes, correct. That is the report of the executive director. It didn't purport to be the official position of the commission on the interpretive question. It simply was analyzing the potential economic impact of McGirt as the executive director was directed to do by the governor in the wake of the McGirt decision.
Counsel, all of this discussion over the economic impact sounds legislative to me. It's policy driven. Are you suggesting that we look at what the ramifications of our holding will be, or that we follow the law as we see that it is written by the policymakers, which we are not?
Vice Chief Justice Rowe, for purposes of the state law question here, we're content to rely on the text, the fact that the text here is different from the text in federal law. And I think that the other side's argument here rests entirely on the proposition that this different language should be read as coterminous with the language in Section 1151.
But Counselor, Justice Rowe's question is true when you're talking about maybe strict construction of statutory interpretation and how the state wants to interpret their own rules. But isn't it something, and you haven't gotten there yet, but I'm pretty interested in it, don't we look at those type of economic possible harm if we're looking at things like custom and usage, which was considered in the Sherrill case?
Yes, thank you. And I was just going to say to Vice Chief Justice Rowe that those considerations do matter once we get to the balancing of interests and to the equitable considerations for purposes of federal law. And I'm happy to go directly there.
Doesn't the report that the commission didn't bless say there will be harmful economic problems for the state based on the McGirt decision?
Yes, and I think that that explains why, if the right way to think about the preemption question here is in terms of a balancing of interests.
Right, but I'm just making the point that the report that they want us to take note of also takes note of those income type problems, correct?
Yes, and I don't think that there's really any dispute between the parties about the magnitude of those problems. The tribe certainly attempts to sort of minimize it, but again, we all recognize that there is going to be this impact on the state fisc over a period of many years going forward if the court resolves this question in appellant's favor. And maybe I should turn directly first to the preemption question and then to the Sherrill question. So on the preemption question, I think where we have a fundamental disagreement with the other side is on whether or not there is, in fact, this categorical rule. And I want to start with what the Supreme Court has most recently told us in this area in the Castro-Huerta case, which is that when you're thinking about preemption, the Supreme Court has said that there is a two-step framework. The first question is there a source of federal law that preempts the state's jurisdiction? And second, does the exercise of state jurisdiction unlawfully infringe on tribal self-government? Now, I hear my friends on the other side to be suggesting that when you think about this line of cases, which really starts with McClanahan, that they should really be viewed not as cases involving a balancing of interests, but instead as cases involving preemption. But if that is so, a notable exclusion from the other side's argument is any effort to identify a federal law, whether a treaty or a statute, that has the preemptive effect here. You know, if you go back to the McClanahan case, which involved the Navajo Nation, that decision discussed the treaty and the federal statutes that apply to the Navajo Nation. Now, why is the other side being so reticent about that in this case? I think the reason is one that was alluded to by Justice Cogger in her question earlier. If the tribe were to take the position that some of the earlier treaties, like the 1830 treaty, did the preemptive work here, that would have massive consequences for state regulation across a whole host of areas, including, for instance, in the area of zoning as it pertains to tribal citizens, or in the area of licensing of tribal doctors and other professionals. And so that is decidedly not the argument that the other side is making. Instead, the other side says, well, look, there's just this categorical rule in this context, such that whenever you have a state attempting to tax tribal members who live within Indian country as it is defined in Section 1151, that there is preemption. Now, there's something a little bit odd about that categorical rule, because why would the scope of federal preemption depend on the scope of the definition of Indian country? Section 1151, by its terms, doesn't preempt anything. It doesn't do anything. It just provides a definition. So it can't possibly be that that is the source of preemptive effect here. And so I think really what the other side is arguing is that the balance of interest whenever you're dealing with a tax just inevitably cuts in the tribe's favor.
Isn't it true that in the Sherrill case, they even pointed out what I was discussing with the other side? Hey, if you don't want to pay tax, talk to the Secretary of Interior to put your land in trust, and then you have your federal preemption, your order of federal preemption, correct? That's a way that is a rule. If it's in trust and the federal government is holding that land for the tribe, the state cannot tax.
That is the Sack and Fox case. So in other words, if you're dealing with land that is held in trust, regardless of whether that land is on a reservation or otherwise, that tax preemption principle applies. We're not disputing that proposition. But when you get down to it, the question before this court on preemption is, does that same preemption principle apply within a territory like the historical Creek territory, where the vast majority of the land is unrestricted and alienated fee land? And there is not a case of the United States Supreme Court that speaks to that. The nearest case is the Moe case. Now, the Moe case was a case in which the Supreme Court said that the principle of immunity extends to fee land. But that was very different territory. That was a situation in which about half of the reservation was owned in fee by both Indians and non-Indians. Most of the rest was trust land, and the court relied on the fact that a contrary interpretation, an interpretation that gave the state taxation jurisdiction on non-trust lands, would give rise to checkerboard jurisdiction. In this context, the balance of interest comes out quite differently. And again, unless the other side wants to identify a treaty or a statute, what this court has to do in the wake of Castro-Huerta is to balance the state's sovereign interest against the tribe's interest. On the state side of the balance, I think I've already referred to the considerations that are most relevant. This court knows that with the historical Creek territory, as with the other 5 tribes' territory, The vast majority of the land is fee land. The state has an obligation to provide services within that territory that are funded with general tax revenues. The state, of course, has been doing that with schools, with emergency services, and the like. And the state has been assessing income tax over tribal members who live on that territory for decades. And so we can dispute how disruptive it would be, but there can be no doubt that the loss of that revenue would be disruptive to the
But this
state.
exemption's been in the law for a number of years. And how disruptive is it now?
Well,
Before McGirt.
the issue that we're dealing with now, Justice Gurich,
Well, just tell me
obviously,
the difference, the numbers before and the numbers after. You told us the numbers now. What were the numbers before?
so I don't have the number for how much was being claimed under the exemption before McGirt. But this issue obviously arose only in the wake of McGirt. Tribal members were not claiming the exemption in Ms. Stroble's circumstances until after the McGirt decision, and then we started to see these claims.
But it just seems unusual that the Tax Commission can't tell us how many people have been claiming this exemption all along. And how disruptive has that been to the services being provided? I mean, we need to be, they're the Tax Commission. They have all the numbers.
We can certainly collect that information and provide it to the
Well, but
court,
it's not part of this record, and it just seems to me
Correct.
as a common sense thing, that would have been part of this record.
But of course, what we're talking about is what is the delta going to be between a ruling in the taxpayer's favor and a ruling in the commission's favor? Because that's really what the court, for preemption purposes, is assessing. The court is assessing the question of whether or not an extension of the exemption to the tribal members working and living on fee land, what would that effect be, and how does that pertain to the balance of interests?
Well,
So
the
I think
difference
there-
would be before, before the numbers would have been narrowly tailored to the definition of formal or non-formal, meaning probably a lot of trust-held land where you could identify, that's what I was asking earlier, exactly the sections of persons that would be exempt, and that could be calculated into whatever budgetary issues would be made. But after McGirt, that is an expansive territory, possibly, which could have different implications.
There can be no doubt that the amount we're talking about now, around $250 million over 3 years, is going to be much larger than the amount that's being claimed.
But we don't do budgets over 3 years, so it's really not $250 million a year, is it?
Well, no, it's 225 over 3 years, it's $75 million per year. So I'm willing to sort of take that as the relevant number. I think that there's no doubt that that is larger than the amount that is being claimed in the exemption outside of fee lands, for the simple reason that, as we've been discussing, fee lands are the vast majority of the territory here. And the only other thing I would say on the preemption issue, and I do want to say just a word with the Chief Justice's leave about Cheryl, is that we think that the tribal interest here is quite slight. The tribe did not challenge the state's authority to tax individuals in Ms. Stroble's position until quite recently, and the state's imposition of an income tax here does not displace the tribe's authority to collect its own taxes. The Creek Nation has not indicated that it would seek to impose an income tax of its own on its own members in this circumstance. It hasn't expressed a desire to do so, and so again, we think that that balance weighs in our favor. And on the issue of Cheryl, I do think that Cheryl may in many ways present this court with a more straightforward path to conclude that as a matter of federal law, there's no problem with the Tax Commission's imposition of the tax in these circumstances. In Cheryl, the court didn't in any way limit its ruling to the particular facts of the case. So to the extent that my friends on the other side are suggesting that the particular theory of revival of tribal sovereignty in Cheryl was the only circumstance in which this equitable principle would apply, I simply don't think that that's correct. And what's the best evidence of that? It's that the Supreme Court, the United States Supreme Court in McGirt, specifically referred to equitable principles such as laches as potentially imposing a limitation on the practical consequences of the court's decision. And that's a discussion at 140 SCT at 2481. The application of the Cheryl principle here is straightforward because the application is in many ways similar to the application in Cheryl itself. There are 3 factors that are relevant. First, the length of time since the tribe exercised sovereignty over the land. Second, the justifiable expectations of the people living in the area. And third, the disruptiveness of a revival of tribal sovereignty today. All three of those factors point in favor of preclusion here.
What is in the record that supports that?
So I would point to the discussion of the history of the Creek Nation in McGirt itself. There's no dispute about the relevant facts here as to the Creek Nation's exercise of sovereign authority. Everyone agrees that the Creek Nation effectively exercised no sovereign authority at the time of statehood. It was authorized to do so in 1936. It began to reestablish the functions of tribal government only in 1980, and it has never regained any sovereign authority over fee land. And so when you take that period of time and compare it with the period of time in the Sherrill case, you know, the length of time in which the tribe was not exercising sovereignty is considerable.
But the Oneida tribe was doing it. I mean, they were taking it under their own initiative to reclaim all of their old land and then just say, I'm declaring this as now the reservation is back intact. That's not what we have here. Were they not prevented from raising these issues earlier? I mean, what would have supported this kind of claim earlier?
So, you know, to be sure, with regard to this sort of claim has only been pursued since the decision in McGirt. But for purposes of the Sherrill analysis, Justice Gurich, the question is not whether the tribe might have wanted to exercise sovereignty. The question is, what was the tribe in fact doing? And again, I think the other two factors point to the same conclusion. When you think about justifiable expectations, Oklahomans had long settled expectations that the state would continue to exercise regulatory control and governance over the fee land within the historical Creek territory. And the third consideration, the disruptiveness of a revival of tribal sovereignty, is the one that we have been discussing. And it's not only the loss of millions of dollars of revenue to the state, it is the uncertainty that would result with regard to civil and regulatory jurisdiction across a host of different areas. And I think we have...
That's speculation. Again, that's not part of this record, is it?
Well, but I think these are legal considerations for this court to consider. And to be sure, you know, I'm not sure how one would go about proving that there is going to be this disruption, other than the fact that we have heard from the tribe representations that the tribe, you know, will assert some degree of authority over zoning on these fee lands. The tribe certainly, on its legal theory, would have the authority to make licensing determinations with regard to doctors and other tribal professionals. And I think that those are precisely the considerations that the Supreme Court considered in the Sherrill case. And with regard to this question of whether or not McGirt somehow limited this decision, you know, I would point to the language in McGirt that, again, recognized that equitable principles would continue to apply, including the principle of laches, which is really the primary equitable principle that was at issue, I think, in Sherrill. And I would also point to the fact that in footnote 9 of Sherrill itself, the court recognized that this question of whether there's an equitable limitation is distinct from the question of whether or not there was a reservation or whether or not the reservation had been disestablished. The Court of Appeals in the Sherrill case had said, you know, that there actually had been no disestablishment. And yet the United States Supreme Court said, we don't have to address that question because this equitable principle operates as an independent bar. And there is no reason for treating this case differently from Sherrill in that regard. The court made clear that the Sherrill principle applies to any claim with an equitable cast. It applies regardless of whether tribal sovereignty was being asserted affirmatively or defensively. And here, Ms. Stroble's claim, as is evidenced by the fact that the tribe has been making most of the arguments today, is entirely derivative of the tribe's own sovereignty. So if the court has any concern about the fact that in the preemption area it would have to deal with and distinguish prior precedents of the United States Supreme Court, on the Sherrill doctrine, all the court has to do is apply that principle and to say that this is the paradigmatic situation in which the failure to exercise sovereignty is a basis for precluding the claim of tribal sovereignty as a defense against the application of state law.
All right, Counselor, you went over your time, but as the first questioner post-argument. I was going to ask about Cheryl, so I afforded you that extra time to speak to Cheryl. So that concludes the questions that I had. Vice Chief?
Well, counsel, isn't Cheryl the weaker of your arguments? Because if we rule in your favor on Cheryl, the U.S. Supreme Court will get the final say potentially as to whether we applied Cheryl, whether it's applicable in this matter. Whereas if we rule as a matter of state law that the Tax Commission has interpreted the state code correctly, isn't that your strongest position?
Well, we certainly think that the Tax Commission interpreted the administrative code correctly. The federal law arguments here come into play simply if the court concludes that that there is a potential federal problem. In other words, it's really the other side that's saying that the Tax Commission lacks the authority to do this. And we're saying there are sort of two reasons why the Tax Commission has the authority to do this. The first is preemption does not apply in this context, that the Tax Commission, in fact, has the authority to do this. And if the court disagrees with that, we think that Cheryl would independently, as a matter of federal law, authorize the Tax Commission to do this. So these federal law issues really only come into play if the court rules in our favor, as it should, on the interpretation of state law. I would note that these federal issues are going to get teed up in one context or another eventually. Even if this court were to rule against us as a matter of state law, if the Tax Commission were to come back and to amend the regulation, those arguments, the same arguments that Mr. Kanji is making today, he would presumably make in the next case.
Thank you. Justice Cogger?
No, I was curious when you said that they didn't bother to challenge it earlier, when actually this is the first, isn't that what you said?
Oh, no. I mean, I think my point was simply that the tribe has not, the tribe and tribal members have not made these assertions since McGirt. I'm certainly not faulting Ms. Stroble for bringing these claims now. Ms. Stroble was one of the many taxpayers who brought these claims in the wake of McGirt, and the claim was obviously processed through...
But you inferred years before, earlier, traditionally, they had not brought any of these claims.
Well, I made that point in connection with the assertion of tribal sovereignty and the tribes.
Tribal sovereignty has been recognized now.
Correct.
President Nixon was the grandfather of the tribal sovereignty, and since that time, tribal sovereignty has been recognized. And initially, the tribes didn't have the money or the opportunity to build briefcase warriors, which they now do. And this is really maybe the second generation where they've had that opportunity. So there's probably a pretty good reason that they didn't launch an appeal.
So I think that there are two reasons why, all of these timing considerations are significant. The first is with regard to Bracker balancing. And again, in Bracker balancing, the court is to balance the effect on the state against the interest in tribal self-government. And on that point, our submission is simply that, the tribe's interest in its members not being subject to state tax is not one that it asserted until quite recently, but it's also one that I would submit is relatively slight here, because the imposition of a state income tax does not limit the tribe's prerogatives, particularly in a circumstance where the tribe itself is not saying, we want to impose an income tax of our own, and this would lead to onerous or double taxation. I think the other way in which it's relevant is that it is relevant to the analysis for purposes of Cheryl, for the simple reason that as a broader matter, the tribe was not exercising its sovereign authority over fee lands for a lengthy period of time. And Mr. Kanji's response in his brief is, well, there was a period of time when the federal government was obviously preventing the tribes, not just the Muscogee Creek Nation, but other tribes, from exercising sovereignty. Of course, one could say the exact same thing about Cheryl. But my point is that even if you take those time periods into account, there was a lengthy period of time during which the Creek Nation made no effort to exercise sovereign authority over fee lands. And that is really the critical consideration for purposes of Cheryl.
Justice Winchester?
I waive, Chief.
Justice Combs?
I'll waive, Chief.
All right, Justice Gertz, you jumped in earlier, but do you have any final questions?
No, but I just would like to go on the record that I have read the Tax Commission report, and they do say at page 8, which is 194 of the record, that clearly the Creek Nation, the Creek Reservation survived this under McGirt, and that therefore provisions of Oklahoma Administrative Code 71050-15-2 now apply in all lands in the reservation. You made mention before that we should ignore this report because it really doesn't say that. It really does say it. It's just, is this an admission against interest? Is this anything legally that we should hang our hats on? I don't think anybody disagrees with that it is none of the above, but it's clear that the first blush of the Tax Commission was that absolutely this is a pretty common sense interpretation. So I just wanted to clarify that some of us have read that report.
Oh, and I'm fully aware of the sentences that you're referring to. I think they're on page 194 of the record. And I would just, reiterate, 2 points. The first is that, again, this was a report of the executive director simply assessing the potential impact of McGirt. I don't think the executive director was purporting to parse the language in the regulation. But second, it is decidedly not the official position of the commission. When the commission is taking positions on Oklahoma tax law, it does it, as this court is aware, in 2 ways. First, in the regulations themselves, and second, in the interpretation of the regulations in the context of administrative adjudications like this one. It decidedly does not interpret Oklahoma law in the context of reports analyzing financial impacts.
Well, initially, the ALJ followed the report, right?
The ALJ took the contrary position, and the commission, pursuant to its procedures, reviewed this issue en banc and came out the other way. And that is, as this court is aware, how the commission resolves refund actions in the administrative process.
Justice Darby?
No questions, Chief.
And Justice Keene?
Yes. Sir, I think it's in the order from the Tax Commission, but they cite a case, I don't have it, that income tax is calculated upon the time it is earned, correct? So in 2018, 2019, and 2020. Is that correct?
Yes, that's correct.
And McGirt was decided in August, I believe. July, the summer of 2020. So if we're just looking at a small little portion of what we're talking about today, how is not Castro and the fact that this isn't retroactive applicable to these 3 tax claims that she's trying to argue today?
So my understanding of the way that this works is that, the effective limitations period for these claims is 3 years. So a taxpayer, these taxpayers started bringing these claims in the wake of McGirt in July of 2020, and they went back 3 years. In many cases.
Believe me, I know. We had a tax case recently where we were discussing when this actual 3-year period came through. But I thought it was interesting that the income tax is calculated upon when it's earned, meaning claiming an exemption or what you owe. I'm assuming that they cited that because their argument was, even though you can request a refund within 3 years of the time, the basis of that income itself is different. That's a different type of tax question. But we don't have to talk about that anymore. My very last question is, with Cheryl and the equitable decision, obviously the Cheryl case was a very interesting position. A tribe that had their lands taken, then they were back, then they were sold, then they were buying them back. I mean, that is an interesting one-time case. Would you agree? I mean, the facts of that case.
The facts of the case were unusual.
Right. So could you agree with me that the situation we're in here with McGirt, and after years of believing that there was not an established reservation, and the Supreme Court says, oh yes, Congress has to disestablish that reservation, that this is also a very unique situation that we're all having to discuss?
So I would agree with that, but I would say one thing in response to that, which is that I don't think that the equitable principles that the court announced in Cheryl were limited to the particular context of an effort to reunify.
But don't you look towards equity in that type of discussion in an unusual type of situation? That's my point.
Well, and one might then wonder why the court in McGirt referred to these equitable principles. And
well, actually, didn't they reject common usage? And they were like, hey, listen, we know this has been this way, but we know that the state can work it out with the tribes and everything's going to be okay. So they didn't really look at Cheryl equitable principles in McGirt. I thought they dismissed that concept. That was going to be my question to you. What's the difference between McGirt and Cheryl, and why should we go with Cheryl and common usage issues versus McGirt, which said, we don't really care?
Well, what the court said in the portion of McGirt that we've been referring to is many other legal doctrines, procedural bars, res judicata, statutes of repose, and latches, to name a few, are designed to protect those who have reasonably labored under a mistaken understanding of the law. And I think that that is precisely what Cheryl is about. Cheryl is about circumstances in which a tribe has ceased to exercise its sovereign authority, such that as a matter of broader equitable principles, it would be inequitable to use that sovereign authority to operate as a bar against the ordinary operation of the law. That is exactly what we are advocating here today. And as Vice Chief Justice Rowe was asking, I think that there is a very good chance that the federal law issues that are presented in this case are ultimately going to have to be resolved by the United States Supreme Court. Both the question of the extent to which federal law preempts state law and the question of the application of Cheryl. Both of those issues have broader consequences beyond the tax context for the other contexts that we've been discussing today, such as the context of licensing and zoning and the like. Right. So I don't think that there's really much that the court can do to avoid that. Those chips are going to fall where they may in Washington at some point down the road. But I think that the better interpretation and the most faithful interpretation of the United States Supreme Court case law to date is that federal law does not operate as a bar here. And the last thing I would say, I think I understood the import of your question, Justice Keene, about timing. I think with regard to claims for tax years before McGirt, we have not disputed that taxpayers could bring those claims, because McGirt, of course, was determining not just from 2020 going forward, but of course determining going back as well that eastern Oklahoma does constitute Indian country for purposes of federal law. So leaving aside the Matloff case and cases involving independent doctrines of retroactivity that apply, for instance, in the context of criminal law, we have never taken the position that the only claims that could be brought are claims for income that was accrued after July 9th, 2020.
All right, well, that will conclude your argument, and we appreciate your assistance to the court.
Thank you, Chief Justice.
And now we'll seek a little help for 12 minutes of rebuttal.
Thank you, Chief Justice King, and may it please the court. I will track Mr. Shanmugam's presentation and start with the state law issues. And there, I'm with Vice Chief Justice Rowe. I think C means C. When the Oklahoma Tax Commission said C-1151, I think it beggars belief to say that it meant that in some kind of casual way. And this is a tax regulation. Tax regulations are not interpreted as traps for the unwary. They are interpreted to be precise. It's very hard to know what C would mean other than look to 1151 for the definition. And even if that's all we had, I think that would suffice. But again, we have more, because the OTC itself has said that it adopted the regulation in response to the Sack and Fox case, which used formal and informal reservations as a synonym for 1151's reference to any reservations. It was simply trying to capture all manner of reservations, whether ones formally established by Congress or ones where land is taken in a trust or restricted fee outside of formal reservation boundaries. And again, the OTC opinion I cited from 2021 reiterates that the OTC made the conscious collateral drafting choice to incorporate section 1151 into the tax regulation. So I really think there is no room to argue other than that the tax rule follows the federal law. And with respect to the federal law, and this goes back to Justice Cotter's questions to me originally, what is meant by a formal reservation? Why would the Muscogee Creek Nation reservation not be a formal reservation? We heard one argument and one argument only, which is that the Creek Nation originally was given a fee pattern, a restricted fee pattern, rather than a trust pattern to its lands. And that somehow in the views of the OTC makes it a lesser reservation. If that sounds like a familiar argument, it is because it is. It is exactly the argument that the state of Oklahoma made to the United States Supreme Court in McGirt, and that not a single justice, majority or dissent, accepted. And the reason is this: the court said there is absolutely no support for the proposition that a reservation cannot be held with an underlying fee pattern. We have examples of such reservations throughout the country, and the argument, in fact, is historically perverse because the Creek Nation insisted on a fee pattern for its reservation in order to enjoy greater, not lesser, protection for the reservation lands, as the McGirt court held. The OTC is making this argument to this court without even acknowledging that it was an argument heard and rejected by McGirt. I think it shows a great disrespect for this court and for the United States Supreme Court to recycle arguments that have so recently been rejected and that are contrary to federal law and to the course of history. The Creek Nation reservation is a formal reservation under any understanding of the term, which takes us to federal law. Mr. Shanmugam talked about two things, preemption and Cheryl. I will again address those in turn. It's very interesting when Mr. Shanmugam talked about preemption. He said you can have preemption by treaty or by statute. Well, he left out one very important document, the United States Constitution. And the Supreme Court has been clear that ordinary principles of preemption include preemption by federal statute, by federal treaty, or by the provisions of the Constitution itself. In the Kansas v. Garcia case in 2021, the court reiterated that principle. And everything we have talked about this morning, the categorical per se rule against state taxation of reservation Indians, is a rule of preemption. McClanahan, which is the granddaddy of the state income tax cases, describes it as a rule of preemption. Cabazon describes it as a rule of preemption. Sack and Fox describes it as a rule of preemption. In the Castro Herrera court, its holding was clear. States enjoy jurisdiction throughout their territory, including Indian country, except where federal law preempts that jurisdiction. And that's exactly what we have here, a clear rule of preemption. And I could recite 10 cases, I'll recite just one where the Supreme Court has rejected this notion again and again that balancing, that the courts, like this court, are meant to rebalance interests in this area. This is from Justice Scalia, who was a justice who was certainly sympathetic to state interests. He said in the Yakima case, "We have traditionally followed a per se rule in the special area of state taxation of Indian tribes and members. Balancing on interests is not the gauge for determining validity, since it is that very balancing that we have reserved to Congress." Which goes to Vice Chief Justice Rowe's question. The arguments being made here are legislative arguments. They are not judicial arguments. We have a clear principle of law which has clear application in this situation. To show how far the OTC wants this court to depart from the law, it's also very important to keep in mind that in the clear line of cases about the per se rule and no balancing, the argument, because Castro Herrera was a case about non-Indians, not about state jurisdiction over Indians, the argument is that the Supreme Court somehow implicitly overruled that entire line of cases. Well, the United States Supreme Court has been very clear that state Supreme Courts, lower federal courts, should never deem one of its precedents implicitly overruled. In the Bossie case in 2016, the Oklahoma Court of Criminal Appeals had held exactly that a U.S. Supreme Court opinion had been implicitly overruled by subsequent opinion. And the Supreme Court of Bossie said, no, that was not the prerogative of the OCCA. We determine when we've overruled our precedent, and there is no case here, any claim that there's any case here, that has overruled the clear precedent that reservation Indians are per se exempt from state taxation, and that balancing does not apply. Finally, to Cheryl, and I feel very strongly about some of the statements that have made here, which again might sound familiar because they were statements made by the state in Oklahoma. Mr. Shanmugam is categorically incorrect when he says that the Creek Nation, that everyone agrees that the Creek Nation ceased to exercise governance over the Creek territory. That is simply not true, and McGirt found it not to be true. Even at the nadir, when Congress was squeezing Indian tribes and Indian reservations around the country at the turn of the century, at the time and state of the McGirt court said the Creek Nation fought to exercise governance. And one of the examples it gave of governance was that the Creek Nation continued to enjoy the power of taxation, the very power we're talking about in this case. Mr. Shamley would have you take a 30-year period where Congress and the federal government were squeezing tribes around the country and use that to argue that today, where tribes are exercising robust governance for the benefit of all, that somehow their power should be squelched out. Well, that's exactly what the McGirt called the rule of the strong, not the rule of law. And this court is here to uphold the rule of law. The arguments about consequences here, yes, I agree. Where I come from, $70 million is certainly not pocket change. But $70 million is not a warrant to depart from the law, especially in the context of a situation where, on these very grounds, in 2 weeks' time, the governor will be calling for a cut, a state income tax cut, because he says there's plenty of money in the state coffers to warrant giving money back to individual Oklahomans. Well, that necessarily means there is money to honor following the rule of law and to respect tribal sovereignty. And it is exactly that which we are asking this court to do. I will invite any further questions from the board or otherwise I will address.
All right, I don't have any further questions. Vice Chief?
Well, I appreciate all the arguments today. I appreciate the preparation of counsel. Counselor, as to the policy, and you know my reticence for a court, based on my questions, to delve into policy. That's above our pay grade. But the policy here flows both ways, does it not? Because if we rule in your favor, and the domino effect is of catastrophic consequence to the budget of the state of Oklahoma, there may be a call to Congress to disestablish these reservations. So this goes both ways, does it not? And have you considered that?
Yes, absolutely, Your Honor. And it's a great question. And we have to consider in arguing McGirt, Congress does ultimately have that plenary authority. And so one always does have to have that concern. But here we have a nation which has made the decision to continue trying to govern in a responsible way for the benefit of all citizens within its territory, and hopes and trusts and believes that the spirit of cooperation between the tribe, between the nation, the state of Oklahoma, which has predominated for a very long time in the state, that spirit will return in full force. And I think this court has a very important role to play in that, and I fully agree with your distinction between policy and law. I think it's a fundamental distinction for the court. Honoring, reaffirming baseline rules, like the clear black letter rule here, is extremely helpful and important in fostering cooperation and reducing conflict. Because when parties are arguing over what the rules are and having to re-argue what the rules are, that makes it more difficult. When people accept that there are principles on which they have to act and that they're going to live with those principles, they can then work on cooperation. And that's exactly what the nation is inviting and hoping for.
One other quick question, Chief, if I may. Counsel, would you also agree, as I mentioned to your opposing counsel, that although we are the Supreme Court of Oklahoma, essentially we're marking time. We don't get the final say. The U.S. Supreme Court ultimately will say whether 1151 is extended, or if there's a Sherrill test, or Congress will determine the reservation status. But that's where this is headed, is it not? On either side, that's where this is headed.
Well, it may or may not. I think, and I mean this very candidly, if this court were to uphold the rule of law, to vindicate the black letter principle, I'm not sure that the United States Supreme Court would take that case, because it would not create a conflict with any established precedent. And it would be viewed as a state Supreme Court respecting tribal sovereignty. It's very interesting. In the 1990s, there was a string of cases, and it's no coincidence that a lot of the tax cases come out of Oklahoma, because there was a long period of time where the Oklahoma Tax Commission, the Oklahoma courts, were not respecting the sovereign rights of tribes and were ruling against these immunities. In cases that had to keep going up to the Supreme Court would say, no, we meant what we said, respect tribal sovereignty. We then had a period of time with a great deal of compacting and cooperation where that wasn't happening. And the U.S. Supreme Court did not have to intervene in Oklahoma affairs. The rule of law was honored. And I think that might well be the case if this court were to rule in our favor again.
Justice Cogger?
I don't really have a question for you, but I do have a question for opposing counsel. Why didn't you change it?
You may.
The Tax Commission's view was that our interpretation was simply the better interpretation of the text of the regulation. And ultimately, of course, if this court were to disagree with us, the Tax Commission would have the prerogative to amend the language, but we believe that the plain text supported our interpretation.
Thank you.
That's it? All right. Justice Winchester?
I appreciate both counsel's argument. It's been valuable to me, and appreciate all parties. I waive.
Justice Combs?
I likewise appreciate the argument. It's been very helpful. Thank you very, very much. I waive, Chief.
Justice Gurich?
This has been very helpful to all of us. I appreciate the high level of preparation on both sides. Thank you all.
Justice Darby?
Thank you, and I waive.
Justice Keene?
Well, I just have a thought. You're talking about the governor and his special session call. Are you also aware, and I'm going to ask you, I think that there's all policy moving decisions everywhere, that the Bureau of Indian Affairs through President Biden just passed something in early December, trying to make it easier, faster, and more efficient for tribes to take lands into trust, even within a reservation, and citing the McGirt definition. So you would agree that there's things moving all over the place, that maybe we should just look at what's in front of us and what else is around and what's going on federally or state-wise is going to play out based on what we decide. Probably it's just one step in what will become something up probably to the Supreme Court.
Well, I would not underestimate the significance of how this court rules. And I mean this, I practice in this area around the country, and where state Supreme Courts vindicate principles of federal Indian law and demonstrate respect for tribal sovereignty, it has a tremendous consequence, both judicially and beyond in society at large. So I would not underestimate the significance of this.
Thank you. I want to join the rest of the court in saying that I really appreciate you and counsel's preparation today. It's been extremely lively discussion and very helpful, and I truly appreciate it.
Thank you very much.
Justice Cogger, you had another thought?
I did. I would like to commend each of you on your preparation. I've been here not as a justice, but as a person on the court staff for 52 years, and this is a rare occasion in oral argument. Congratulations. It was excellent.
Thank you very much. And again, we appreciate the opportunity.
And the Chief gets the last word, and I agree with Justice Cogger. We'll be in recess.